Appendix 11. The Constitutional Law of Privacy, Past, Present, and Future, by Herbert W. Titus, Professor of Law. Past. The current outcries for women's rights to state-financed abortions, for homosexuals' rights to state protection from discrimination, and for other so-called privacy rights have roots deep in America's constitutional past. As early as 1795, 4 years before Chief Justice John Marshall established judicial review in Marbury v. Madison, Justice Samuel Chase asserted, in the case of Calder v. Bull, that a legislative act, contrary to the general principle of law and reason, cannot be considered law even if there was nothing expressly written prohibiting that exercise of power in either the state or federal constitutions. Justice Chase claimed that the court's constitutional authority and duty required it to test any legislative act by the great principles of the social compact. The people of the United States erected their constitutions to establish justice, to promote the general welfare, to secure the blessings of liberty, and to protect their persons and property from violence. The purposes for which men enter into society will determine the nature and terms of the social compact, and as they are the foundation of the legislative power, they will decide what are the proper objects of it. The nature and ends of legislative power will limit the exercise of it. Emphasis in original. In opposition to this loosely stated view of constitutional law, Justice James Iredell asserted that the American constitutional experience reflected a quite different assumption. It has been the policy of all the American states, which have, individually, framed their state constitutions since the Revolution, and of the people of the United States, when they framed the federal constitution, to define with precision the objects of the legislative power and to restrain its exercise within marked and settled boundaries. Calling Chase's views those of a, quote, speculative jurist, end quote, Justice Iredell summed up his position to any contention that the courts had authority to pronounce a law void because it was contrary to the principles of natural justice. The ideas of natural justice are regulated by no fixed standard. The ablest and the purest men have differed upon the subject, and all that the court could properly say in such an event would be that the legislature, possessed of an equal right of opinion, had passed an act which, in the opinion of the judges, was inconsistent with the abstract principles of natural justice. When Chief Justice Marshall wrote Marbury v. Madison in justification of the court's authority to review congressional enactments under the federal Constitution, he sided with Justice Iredell, not Justice Chase. While he recognized the, quote, social compact, end quote, as the foundation of the American fabric of government, he did not agree with Chase that the simple exercise of the right of the people to establish a government to promote their own happiness established constitutional legal limits on the powers delegated to a legislative body. Rather, he believed that those limits only came if they were expressly embodied in a written constitution. That the people have an original right to establish, for their future government, such principles as, in their opinion, shall most conduce to their own happiness, is a basis on which the whole American fabric has been erected. This original and supreme will organizes the government and assigns to different departments their respective powers. It may either stop here or establish certain limits not to be transcended by those departments. The government of the United States is of the latter description. The powers of the legislature are defined and limited, and that those limits may not be mistaken or forgotten. The Constitution is written. The Chief Justice's argument was twofold. First, the powers granted to the federal government had been limited, and second, those limits had been embodied in a written constitution. He stressed the latter point repeatedly and rested his case for the institution of judicial review squarely upon the fact that the Constitution had been reduced to writing. Certainly, all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation, and consequently, the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. This theory is essentially attached to a written constitution and is consequently to be considered by this court as one of the fundamental principles of our society. While Chief Justice Marshall's opinion rested in the institution of judicial review on the existence of a written constitution, the, quote, natural justice, end quote, philosophy found in Justice Chase's remarks in Calder versus Bull has survived 175 years of United States constitutional history. While it has a checkered past, and while it appeared dead after its heyday in the, quote, liberty of contract, end quote, cases in the late 1800s and early 1900s, the presupposition that the judges have a right to review the constitutionality of legislative acts, notwithstanding the absence of an explicit written constitutional restraint, has come into the fore once again in the cases establishing the so-called right of privacy. In 1965, the United States Supreme Court decided the case of Griswold versus Connecticut. In that case, the executive director of the Planned Parenthood League of Connecticut had been prosecuted and convicted for aiding and abetting married persons in the use of any drug or device for the purpose of preventing conception in violation of the laws of Connecticut. In a 6-2 decision, the majority struck down the Connecticut statute as having violated the 14th Amendment's prohibition against state denials of, quote, liberty, end quote, without due process of law. While the 6-man majority could not agree on a single opinion, Justice Arthur Goldberg wrote on behalf of 2 other colleagues the opinions which has since become the foundation of the constitutionally recognized right of privacy. Utilizing the 9th Amendment as a convenient vehicle for grafting onto the Constitution the principle of, quote, natural justice, end quote, Justice Goldberg wrote, the 9th Amendment shows a belief of the Constitution's authors that fundamental rights exist that are not expressly enumerated in the first 8 amendments, and an intent that the list of rights included there not be deemed exhaustive. In determining which rights are fundamental, judges are not left at large to decide cases in light of their personal and private notions. Rather, they must look to the traditions and collective conscience of the people to determine whether a principle is so rooted there as to be ranked as fundamental. The inquiry is whether a right involved is of such a character that it cannot be denied without violating those fundamental principles of liberty and justice which lie at the base of all our civil and political institutions. In his dissenting remarks, reminiscent of his 18th century colleague Iredell, Justice Hugo Black reacted to this revival of the, quote, natural justice, end quote, constitutional law thesis. My brother Goldberg has adopted the recent discovery that the 9th Amendment, as well as the Due Process Clause, can be used by this court as authority to strike down all state legislation which this court thinks violated fundamental principles of liberty and justice, or is contrary to the traditions and collective conscience of our people. He also states, without proof satisfactory to me, that in making decisions on this basis, judges will not consider their personal and private notions. One may ask how they can avoid considering them. Our court certainly has no machinery with which to take a Gallup poll, and the scientific miracles of this age have not yet produced a gadget which the court can use to determine what traditions are rooted in the collective conscience of our people. Moreover, one would have to look far beyond the language of the Ninth Amendment to find that the framers vested in this court any such awesome veto powers over lawmaking, either by the states or by the Congress. This conflict in the Griswold case did not rise full-blown after laying dormant for 167 years. Rather, it has constitutional roots in two earlier episodes of American history. First, the ratification of the Civil War amendments to the United States Constitution and an 1872 United States Supreme Court decision interpreting those amendments, and second, the rise and fall of constitutional, quote, economic liberty, end quote, in the name of due process of law in the United States Supreme Court cases beginning in the early 1900s and extending into the 1930s. Just 2 years after the ratification of the 15th Amendment to the United States Constitution, the last of a series of 3 constitutional changes designed to protect the needy freed slave from hostile action against him, the United States Supreme Court, in the slaughterhouse cases, faced its first major task, calling for an interpretation of the newly ratified 13th and 14th Amendments. Ironically, the plaintiffs in this case were not members of the newly freed slave class, nor did they claim that they were victims of hostile actions taken against them as a class. Rather, the plaintiffs were independent butchers from New Orleans, Louisiana, who contested the constitutionality of a Louisiana state statute granting an exclusive privilege to operate a slaughterhouse in New Orleans to a legislatively chartered corporation so that they could no longer butcher animals in any place where they pleased. They claimed that this legislatively conferred economic favour violated the newly created guarantees embodied in the first 2 Civil War amendments. A bare majority of 5 out of 9 justices rejected this claim on the ground that neither the prohibition against involuntary servitude nor the new guarantees of freedom from state abridgment of federal privileges and immunities, from state denial of due process or from state denial of equal protection of the laws, had been designed to prescribe a state from granting special economic privileges to any individual or group. The majority, after careful review of the constitutional text, its history and purpose, concluded that if the New Orleans butchers had any constitutional right to be protected from the economic favoritism conferred upon the new Louisiana Corporation, that right was to be found in the state constitution, not in the newly elected 13th and 14th Amendments. Indeed, many state constitutions contain prohibitions against the granting of special economic favours to a privileged few. But the slaughterhouse majority refused to transfer those traditional state protections into the newly enacted privileges and immunities, due process and equal protection clauses of the 14th Amendment. While the majority refused to allow the politically disappointed New Orleans butchers to enshrine into the federal constitution rights that are not there, the dissenters welcomed the opportunity to expand the new privileges and immunities, due process and equal protection clauses to include the claimed, quote, economic freedom, end quote. Couched in appropriate legal language respecting the, quote, intent of Congress, end quote, one dissenter, Justice Stephen J. Field, drew on the common law of England, various state court decisions under the state constitutions, and natural justice to find a federal constitutionally guaranteed, quote, right to pursue a lawful employment in a lawful manner. After all, Justice Field, resurrecting Justice Chase's Calder versus Bull social compact theory, reasoned that grants of exclusive privileges, such as it, made by the Act in question, are opposed to the whole theory of free government, and it requires no aid from any Bill of Rights to render them void. That only is a free government, in the American sense of the term, under which the inalienable right of every citizen to pursue his happiness in unrestrained except by just, equal, and impartial laws. While Justice Field's views did not prevail in the slaughterhouse cases, 35 years later, a bare majority of the United States Supreme Court did follow in his footsteps in the case of Lochner versus New York. This time, the plaintiff, owner of a bakery in the state of New York, claimed that a state labor law which prohibited his hiring an employee to work for more than 60 hours in 1 week denied him his liberty without due process of law. In sustaining the plaintiff's claim, the court's majority made no effort to show that the right claimed was one placed in the Constitution by the post-Civil War Congress, the architect of the 14th Amendment. Rather, it drew simply from a laundry list of, quote, liberty, end quote, rights that the court, 8 years earlier, had made in its opinion in Allgaier versus Louisiana. The Allgaier list, almost identical to that rejected in the slaughterhouse cases, read as follows. The liberty mentioned in that amendment, the 14th, means not only the right of the citizen to be free from the mere physical restraint of his person, as by incarceration, but the term is deemed to embrace the right of the citizen to be free in the enjoyment of all his faculties, to be free to use them in all lawful ways, to live and work where he will, to earn his livelihood by any lawful calling, to pursue any livelihood or avocation, and for that purpose, to enter into all contracts which may be proper, necessary, and essential to his carrying out to a successful conclusion the purposes above mentioned. It was this, quote, right of contract that the court elevated into a constitutional privilege in Lochner, a right not found anywhere in American constitutional history, whether federal or state, or even in English common law. The court manufactured the freedom to contract out of whole cloth and then proceeded to allow those exceptions with which it agreed and to reject all those exceptions with which it disagreed. In reaction, Mr. Justice Holmes, dissenting in Lochner, wrote the famous sentence, "The 14th Amendment does not enact Mr. Herbert Spencer's social statics." Mr. Justice Holmes did not, however, issue a call for the court to return to the text and historic purposes of that amendment. Rather, he simply desired a different result. I think that the word liberty in the 14th Amendment is perverted when it is held to prevent the natural outcome of a dominant opinion, unless it can be said that a rational and fair man necessarily would admit that the statute proposed would infringe fundamental principles as they have been understood by the traditions of our people and our law. This desire, a far cry from the one articulated by the Constitution's drafters and Chief Justice Marshall, was elevated into constitutional doctrine in the 1930s by the court as it approved again and again New Deal and other economic measures as having a, quote, rational basis, end quote. But, as the above-quoted sentence from Holmes's dissent proves, nothing is arbitrary or irrational in the abstract. Rather, the benchmark in these cases became whether or not the legislator had violated, quote, fundamental principles as they have been understood by the traditions of our people and our law, Present. While it is true that under the new constitutional formulation, the New Deal and successor courts ceased striking down, in the name of the federal constitution, federal and state measures regulating man's economic affairs. This change came about not because the new justices found nothing in the text, history, or purposes of the written constitutional guarantees prohibiting such measures. Rather, they consistently reserved the right to pronounce an act unconstitutional if it was found to be irrational or arbitrary. While Justice Field's constitutional philosophy set forth in his dissent in the slaughterhouse cases did not provide lasting constitutional victories for the economic interests in this country, his philosophy had not been rejected. It was not until the 1960s and the 1970s, however, that this truth became clear as the court began to struggle with constitutional claims for the right of privacy. Only two justices, William O. Douglas and Hugo Black, acknowledged the link between the claimed rights of marital privacy in the Griswold case and the earlier discredited, quote, economic liberty, end quote, cases. Justice Douglas, writing in support of a constitutional marital privacy right, admitted that it could not be found in any specific text of the Constitution. Rather, he concluded that it was contained in the penumbras formed by emanations from those guarantees, found in the First, Second, Third, Fourth, and Fifth Amendments. But the quote-unquote penumbras were neither shaped nor contained by reference to constitutional text, history, or purpose. Rather, Justice Douglas concluded by openly acknowledging the extra-constitutional origin of the rights of marital privacy. We deal with a right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together for better or worse, hopefully enduring, and intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. Yet it is an association for as noble a purpose as any involved in our prior decisions. While Justice Douglas found no constitutional text to support the results he desired to reach, he found a convenient case precedent in Meyer versus Nebraska, a 1923 case striking down a Nebraska statute prohibiting the teaching of any language but English in the first 8 grades of the public and private schools. In support of its holding, the court in Meyer had concluded that a German teacher's liberty to teach was protected from the Nebraska law under the 14th Amendment Due Process Clause and reasoned, in part, as follows. While this court has not attempted to define with exactness the liberty thus guaranteed, the term has received much consideration, and some of the included things have been definitely stated. Without doubt, it denotes not merely freedom from bodily restraint, but also the rights of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. 11 years later, Justice Blackmun relied on the Meyer precedent when he wrote the majority opinion in Roe v. Wade. The abortion case, which established a constitutional right of privacy, broad enough to encompass a woman's decision whether or not to terminate her pregnancy. The Constitution does not explicitly mention any right of privacy. In a line of decisions, however, going back perhaps as far as 1891, the court has recognized that a right of personal privacy, or a guarantee of certain areas or zones of privacy does exist under the Constitution. In varying contexts, the Court has indeed found at least the roots of that right in the concept of liberty guaranteed in the first section of the 14th Amendment, see Meyer v. Nebraska, 262 U.S. 390, 399, 1923. Thus, the right of privacy that has been endorsed today in the abortion and other related cases has roots in a, quote, natural justice, end quote, constitutional law methodology that was explicitly rejected by the framers of the Constitution and by the Supreme Court itself in the first 100 years of its existence. Today, while there are a few who protest this heresy, most welcome the casting off of the 18th century written constitutional straitjacket. Not only has the current Supreme Court, both quote-unquote liberals and quote-unquote conservatives, endorsed this way of doing constitutional law, so have most constitutional law scholars. Preeminent among the latter is Harvard law professor Lawrence H. Tribe, a prolific writer and author of the recently published treatise, American Constitutional Law. In his preface to that 1,174-page volume, Professor Tribe unabashedly endorses the, quote, natural justice, end quote, philosophy. The Constitution is an intentionally incomplete, often deliberately indeterminate structure for the participatory evolution of political ideals and governmental practices. In words that echo Justice Samuel Chase's philosophy stated nearly 200 years earlier, Professor Tribe updates the, quote, social compact, end quote, theory of constitutional law. The highest mission of the Supreme Court, in my view, is not to conserve judicial credibility, but, in the Constitution's own phrase, to form a more perfect union between rights and rights within that Charter's necessarily evolutionary design. Nowhere is this, quote, evolutionary design, end quote, when imposed upon the Constitution by Mr. Tribe and not by the framers, more evident than in his chapter on privacy and personhood. At times, Mr. Tribe's evolutionary perspective gets away from tight control, as evidenced by the following passage. Society alters, some say evolves. Values change, majorities grow more complacent, factions rigidify. Locked into frozen configurations, legislators may either ignore sound opportunities for progress or opt for novelty without adequate thought of consequences. An unchecked spiral of change ultimately entails the same danger threatened by the most stubborn opposition to change. Either possibility can impart a teleology to positivist law-giving which may equal legislated perpetual conformity. But Mr. Tribe does not allow such elegant asides to divert him from defining the major task confronting the court in the right to privacy cases. Human beings are, of course, the intended beneficiaries of our constitutional scheme. The Constitution was consecrated to the blessings of liberty for ourselves and our posterity, yet it contains no discussion of the right to be a human being, no definition of a person. The judiciary has thus reached into the Constitution's spirit and structure and has elaborated from the spare text an idea of the human and a conception of being, not merely contemplated, but required. So, the true task of the court in today's right of privacy cases is to divine, in the name of the Constitution, what it means to be human. One need not look very deep into the Supreme Court privacy decisions before one realizes how accurate Mr. Tribe's analysis is. In Roe v. Wade, the case which established the constitutional right to abortions, the Supreme Court not only decided that an unborn fetus could not be a person within the meaning of the 14th Amendment, but that essential to the personhood of womanhood was the right to terminate an unwanted pregnancy. What was the source of these rulings? It was emphatically not the Constitution. Rather, it was the common law. Unborn fetuses were not recognized as persons, eligible at common law to sue for damages for tortious wrongs done them, but at the same time, a woman was not prohibited by the common law of crimes from procuring an abortion. How did these common law truths become grafted onto the Constitution? The significance of Meyer versus Nebraska, that's 1923 case, relied on in both Griswold and Roe versus Wade, cannot be overemphasized. While the 1923 court did not specifically include the right of a woman to choose to terminate her pregnancy in its list of liberty guarantees, it had included the general privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. Thus, the courts in the abortion case engaged in its long historical inquiry into the abortion laws and discovered that, at common law, abortion was not a crime. Had it been a common law crime, then presumably the right to choose to terminate a pregnancy could not have been one of the common law privileges referred to in the Meyer case, and therefore could not have been included in the privacy right rooted in the due process liberty guarantee of the 14th Amendment. In a recent action taken by the Supreme Court, this limiting language on the Meyer precedent may have been taken seriously. In Doe versus Commonwealth's Attorney, a three-judge federal court in Virginia refused in 1975 to grant declaratory or injunctive relief to bar enforcement or threatened enforcement of the state's criminal sodomy statute against male homosexuals. The two-man majority opinion concluded its decision by noting the consistent history of prohibition against homosexuality and other sexual perversions. Although a questionable law is not removed from the question by a lapse of any prescriptive period, the longevity of the Virginia statute does testify to the state's interest and its legitimacy. It is not an upstart notion. It is ancestry going back to Judaic and Christian law. The immediate parentage may be readily traced to the Code of Virginia of 1792. All the while, the law has been kept alive, as evidenced by periodic amendments, the last in the 1968 Acts of the General Assembly of Virginia, circa 427. The United States Supreme Court summarily affirmed this decision, and, by doing so, indicated that the constitutional right of privacy will not be extended to an activity, however private, that has a long and consistent history of condemnation at common law and in the early history of our country. Yet, one cannot be too certain. Justice William Brennan, in a 1977 opinion, striking down a New York law regulating the distribution of contraceptives, observed that the court has not definitively answered the difficult question whether and to what extent the Constitution prohibits state statutes regulating private consensual sexual behavior among adults. While Justice Brennan may find such protection in intrinsic human rights, constitutional law expert Professor Tribe believes that natural law and the common law as sources of the right of privacy prove inadequate to serve as either the fount or the guardian of privacy or personhood in the modern era. But what will be the fount and the guardian? Again, the court's opinion in Roe versus Wade has provided the current answer. The wisdom of the 9 Supreme Court justices, appropriately advised by counsel and by others. In the abortion case, the court allowed that a state could limit a woman's rights to terminate her pregnancy in the first trimester by requiring that any abortion be performed by a licensed physician. In the second trimester, by requiring any additional medical safeguards designed to protect a mother's health, and in the third trimester, by imposing any limits designed to protect the life of the viable fetus. Why these criteria were imposed and not others may be explained in part by the fact that the lawyers for the state of Texas defended its anti-abortion statute solely on the grounds that the law was designed to protect the lives of the mother and of the fetus. The state only lamely suggested that the law was aimed also at discouraging immoral sexual conduct. Moreover, the state did not even raise an argument that the anti-abortion law rested on a state legislature's determination that life began at the moment of conception, and that its laws were designed to protect that moral judgment. Given the instrumentalist and utilitarian arguments of the state, the court rendered an instrumentalist and utilitarian decision. As Professor Tribe has put it, the court has chosen not so much a decision in favour of abortion as a decision in favour of leaving the matter, however it might come out in particular cases, to women rather than to legislative majorities. After all, the greater threat to life may, in fact, come from a rule allowing a legislative majority to choose a policy to prohibit abortions, which necessarily would also allow that majority to compel abortions, than from a rule giving that authority over life to the potential mother. Would it have made any difference if Texas had pressed an argument that it had based its anti-abortion statute on a moral judgment that human life commences at conception? Could the state thereby have avoided the result in that case? More important, could a state successfully defend its sodomy laws, which prohibit private consensual adult homosexual activity, by contending that the state has determined that the moral fibre of the community is threatened by private adult consensual homosexual activities? Justice Blackmun stated in the abortion case that the court did not answer the question of when life begins. Texas urges that life begins at conception. We need not resolve the difficult question of when life begins. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary at this point in the development of man's knowledge is not in a position to speculate as to the answer. Notwithstanding this disclaimer, the court proceeded to review the divergent opinions on the question, ranging from the Stoic belief that life begins at birth and extending through various religious positions to the Catholic endorsement that life begins at conception. Justice Blackmun neatly avoided answering the question of when life begins by labelling the fetus potential life, and then by pronouncing the court's moral judgment that potential life deserved protection only at the point of viability. This intellectual sleight of hand was used to support the remarkable statement that we do not agree that, by adopting one theory of life, Texas may override the rights of the pregnant woman that are at stake. Emphasis added. In effect, the court rules that no state may adopt an abortion law based on any absolute moral value about when life begins. In the name of the Constitution, the court has imposed not only a requirement that a state must adopt a relativistic view of life, but that it must endorse only the Supreme Court's relativistic view, namely that life cannot begin before the point of viability. The court's constitutional endorsement of moral relativism has not been confined to the issue of life in the abortion cases. In Planned Parenthood versus Danforth, the court found invalid a Missouri statute requiring, in the case of a married woman, the consent of the husband before the wife could have an abortion in the first 12 weeks of pregnancy, and, in the case of an unmarried woman under the age of 18, the consent of a parent or guardian unless a doctor certified the abortion to be required to save the life of the mother. Recognizing that the state had a legitimate interest in promoting marital and family relationships, the court nonetheless rejected the state's endorsement of a family structure with the husband or the father as the absolute final moral authority. Instead, the court, again on behalf of the Constitution, imposed a relativistic moral model on the family. In the case of the husband and wife, the court found it difficult to believe that the goal of fostering mutuality and trust in a marriage and of strengthening the marital relationship and the marriage institution will be achieved by giving the husband veto power exercisable for any reason whatever or for no reason at all. It is equally difficult to understand how the court's constitutional rule allowing a wife to obtain an abortion without her husband's consent for any reason whatever or for no reason at all will foster and strengthen mutuality and trust in the marriage relationship. Yet, the Danforth opinion requires the state to guarantee the wife's veto over the husband's desires on the decision not to bear the couple's child. This absolute rule, while it might be tempered by a state law requiring the wife to inform and to consult with her husband before procuring an abortion, has been justified by the court as required because it is the woman who physically bears the child and who is the more directly and immediately affected by the pregnancy, as between the two, and the balance weighs in her favour. As for the unmarried woman under the age of 18, the court again voiced scepticism that providing a parent with absolute power to overrule a determination made by the physician and his minor patient to terminate the patient's pregnancy will serve to strengthen the family unit. The court concluded also that the veto power would not enhance parental authority or control where the minor and the non-consenting parent are so fundamentally in conflict, and the very existence of the pregnancy has fractured the family structure. Because the court did not believe in the workability of a family structure headed by a father and mother, it chose to impose on the family a democratic system with power in the child to veto the parent's decision conditioned only upon whether the minor is of sufficient age or maturity to vote. After the court's constitutional forays into morality in the abortion area, the lesson is clear. The only moral values that are now clearly constitutionally impermissible for a state to endorse are those resting upon Christian biblical teachings. A state cannot choose absolutely between life and death, but must structure its criminal laws to reflect a continuum of potential life, potential death, and death. Likewise, a state cannot endorse a family structure designating the husband or the father as the ultimate decision-maker for that family, but must choose a view that accommodates within the family structure democratic and reasonable processes. Given this reading of the abortion cases, the impact of those cases on the claim for homosexual rights is much more significant. The state cannot insist on an absolute ban on private adult consensual homosexual behaviour, because by doing so, it would endorse the view that all homosexual activity and all homosexuals engaging in that activity are equally bad. Such an absolute view of sexual perversion and of man will simply not square with current utilitarian notions of societal harm and with current scientific studies of homosexual choice. As for measuring societal harm, any claim that any homosexual activity causes serious spiritual harm, not only to the participating, related, and neighbouring individuals, but also to the state and nation, does not even fit into the social scientists' empirical measurement formula. It is difficult to imagine either a state's making such an argument or the courts taking it seriously. Without overt biblical support, such as that available in Leviticus chapter 18 and Romans chapter 1, a state will be hard-pressed to show why an absolute ban on homosexual activity is required. Rather, one can already envision the parade of moral goodies that will be marched into court on behalf of homosexual freedom. The problem of overpopulation, the positive contribution of homosexuals to society, and the absence of any scientific data supporting an absolute ban. But the homosexual claim does not stop there. Rather, they attack the basic assumption that underlies all criminal prohibitions against private, adult, consensual homosexual acts. Namely, that homosexual behaviour is a result of a sexual preference over which the actor has control, for which he may be morally blamed. But recent, quote, scientific studies, end quote, point to genetic or environmental factors. While these studies do not unanimously endorse the conclusion that a person has virtually no choice whether he becomes a homosexual or a heterosexual, they point in a direction away from moral responsibility and toward environmental or genetic determinism. If sexual preferences are largely, if not entirely determined, either before birth or in early childhood, then a state could not constitutionally continue an absolute ban on all homosexual behaviour, given the Supreme Court's penchant for relativistic moral standards. But the scientific evidence pointing to genes and environment as the causes of homosexuality cuts an even broader constitutional pathway. It also lays the groundwork for the current claims for gay rights laws, which would prohibit discrimination against homosexuals in housing, jobs, and other activities. In an effort to include homosexuals in the same class as negros, women and illegitimate children, Harvard Law professor Tribe has argued, plainly, the history of homosexuality has been largely a history of disapproval and disgrace. Indeed, it would not be wholly implausible to suggest, just on this basis, that homosexuals form virtually a discrete and insular minority. If Professor Tribe's remarks are taken literally, one would have to draw the same parallel between negros, women and illegitimates and thieves, rapists, murderers, and a host of other malefactors. All criminal classes have a history of disapproval and disgrace. Does Professor Tribe suggest that a state could not discriminate against any person who has been convicted of a crime? Of course not. But his argument favouring a constitutional ruling prohibiting discrimination against homosexuals rests upon the psychological studies that attribute homosexual behaviour to genes and to environment, and not to free choice. The basic presupposition of those studies may be extended to all activities that have been traditionally considered criminal, as noted psychiatrist Karl Menninger has long favoured. Can this logic be ignored by those claiming constitutional protection against state discriminatory practices against homosexuals? Acceptance of the homosexual claim will inevitably open the door for like claims on behalf of all other historical criminal classes. That prospect would certainly have been a startling one to the Congress responsible for the drafting of the 13th Amendment to the United States Constitution. That amendment specifically provides that a person may be placed into slavery or involuntary servitude as punishment for a crime if the party has been duly convicted. If that is true, and if a homosexual could be punished for committing a homosexual act, then there can be no justification under the equal protection guarantee of the 14th Amendment to prohibit any state law discriminating against homosexuals or against any other class of convicted criminals. But this conclusion will follow only if the court accepts, as constitutionally permissible, a state legislature's decision to adopt a moral, not a behaviourist or other psychological model for man. The danger of constitutionally imposing a determinist model on the states has been recognised in Powell v. Texas, where the Supreme Court rejected the contention that a chronic alcoholic could not be held liable for public drunkenness, despite the fact that there was scientific evidence that such a person has no choice but to get drunk. In fact, the whole criminal law system would come tumbling down if the biblical model of man were abandoned in favour of current scientific theories about criminal behaviour. If the scientific theories about homosexuality are imposed on the states by the court in the name of the constitutional equal protection, then there can be no legitimate stopping point to extending the same protection to all other criminal classes. The court could, however, draw an arbitrary line short of this all-inclusive protection. On the other hand, the court could gradually extend the line to alcoholics, drug users, and others who engage in criminal activity. In fact, the United States Attorney General has already included alcoholics and drug users in the class of handicapped persons who are entitled to special government benefits and protection under the Rehabilitation Act of 1973. The erosion away of our traditional assumptions about moral blameworthiness in the areas of sexual preference and drug use will encourage the state to deal with antisocial behaviour by utilising behaviouristic and other methods that Soviet Russia has found convenient in its war against political dissenters. Future. In the right to privacy cases, the United States Supreme Court has extended itself into areas uncharted by the Constitution. Powerful forces in government and in academia have been marshalled to support these newly created constitutional rights in, quote, personal autonomy, end quote. Moreover, the general public has endorsed the privacy rights as a necessary expansion of individual liberty to protect against an ever-growing bureaucratic state. In fact, the constitutional right of privacy cases lay the foundation for the erosion of all liberty, because they represent humanistic man's effort to redefine what it means to be human. The traditional model of man as a morally responsible being is to be displaced by the social science model of man as a machine. If a man can be blamed for making a wrong choice, then he is entitled to the freedom to choose right instead of wrong. Liberty is essential to man as a moral being. But if man is only a machine, then liberty is either an illusion, or worse yet, it is a hindrance to the natural evolutionary processes. The current effort in constitutional law to redefine man is suicidal. In the name of humanity and liberty, the court, unless it alters its course and returns to the historic purposes and written text of the Constitution, will usher in an age of totalitarian manipulation of the human being, because he will be characterized solely by his genes and his environment. Only behaviourist B.F. Skinner or sociobiologist Norman Wilson has cause to rejoice. God's people, however, have no cause to despair. Rather, they can no longer be misled by those who claim that a Christian has no right to impose his religious values on others in society. Without the biblical truths that man is not a machine and that God is not an evolutionary process, law and liberty are impossible. Armed with these truths, the Christian must lead his fellow countrymen back to his true constitutional inheritance. This has been a Chalcedon Foundation production. Produced by Grace Community School and Nicene Covenant Church. Published by Ross House Books. Copyright 1982, 1986, 2001, 2010, Mark R. Rushdoony. If you enjoyed this audiobook, be sure to visit chalcedon.edu for more books and audiobooks by Rusas John Rushdoony.